Okay.
This will get me
And I'm doing Fox and then
through. I just have to write out the agreement for Fox really quick. Do we already have Rob's here on the way?
You have that for you?
I got him to sign it, I just went back there and got it okay, but he's just gotta sign it.
We're ready for Rob's. Immediately. Just want to make sure. Waiting.
Up there somewhere.
Yes. I did find it.
What's the question? Like, you just signed it.
Actually, just get it before you know what it is, but it says it. Yeah. Your signature.
Probation files. Well, now we need to do Rouser first. Alright, we need to do Rouser first since he's just come in. So we'll do that one first, then we'll do Fox.
What we need was first.
Alley. Don't have an alley? Okay. We'll get that done. Okay, am I good? All right, case number 23TA0215FY, people of the state of Michigan versus Jason Christopher Rouser. And attorneys, you can place your appearances on the record, please.
Assistant Prosecuting Attorney Warren Balser, PA 411 on behalf of people.
Good morning, I'm Mitchell Maven on behalf of Mr. Rouser, who's present seat to my right. Go ahead. I'm present seat to my right.
All right, thank you. Today is the date and time set for a preliminary examination in this matter. However, I am holding plea paperwork here in my hand. So Attorney Manuel, your client is entering a plea today?
That is correct, Judge.
Okay, and Attorney Belser, if you can place that agreement on the record,
Thank you,
please.
The defendant having been charged as follows: counterfeiting, count 1, 2, 3, and 4. Count 5 is lying to a police officer. The people will amend count 5 to attempt lying to a police officer, 750.479 C2C. It's a 1-word misdemeanor. The people will dismiss counts 1, 2, 3, and 4. The defendant will plead guilty to the amended charge, count 5. No sentence enhancement, consecutive sentencing, item 7411. I signed this agreement as well.
All right, thank you. And Attorney Manuel, is that your understanding of the plea agreement?
Correct, and accurate recitation of the agreement.
All right, and you signed this plea agreement form?
Yes, Judge.
Okay, thank you. All right, Mr. Rouser, is that what you want to do? You want to plead guilty to attempted lying to a police officer?
Yes, sir.
All right, you can stay seated, but raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth today? I see that you signed the plea agreement as well, correct? I also see that you signed your advice of rights. Is that true?
Yes.
You know and you understand your rights? Knowing and understanding all of your rights, knowing and understanding this amended charge and the maximum possible penalty for the amended charge, how do you wish to plead to the charge of attempted lying to a police officer? Need to make sure that you're giving that guilty plea knowingly and voluntarily. So can you tell me, has anyone threatened you to get you to enter a plea? Has anyone promised you anything other than the plea agreement? I know that you and Attorney Manuel have talked about this matter, but in the end, is it your choice to enter the plea? Were you in the city of Mount Morris in the county of Genesee in the state of Michigan on January 20th of 2023? Attorney Manuel, can you help me?
Yes, and on that date and time, you came in contact with police, correct? And you gave them a name of John Herschel Rouser, correct? And that's not your name, correct? So you lied to a police officer, true? Judge, I believe we have factual basis.
I agree. Attorney Belser, you agree?
Yes, sir.
All right, I'll accept the plea as there is sufficient factual basis to do so. And I also believe the plea was given knowingly and voluntarily today because of the nature of this charge. We can move on to sentencing. Attorney Manuel, what would you like to say on behalf of your client?
Mr. Rouser is an MDOC. His earliest release dated sometime in 2025. He's done over 2 weeks on this case, Judge. I'd ask the court to consider time served.
All right, thank you. You said over 2 weeks, so 15 days
I
be
think 15 days is about right.
accurate.
Because you ultimately got picked up. So once you got picked up in that.
I've been locked up since the case.
I know you have,
But,
but
I think I've done probably just under 2 weeks here in this jail.
he had 2 weeks because you don't get credit for all that time because once they have to detain her, I think 15 days to be credit. I should sentence him to 15 days of credit for 15 days.
Okay. All right, well, considering, before I do that, Mr. Rouser, is there anything you'd like to say?
No, I'm good.
Well, considering Mr. Rouser's position and the fact that he will not be being released from MDOC's custody for quite some time, I am going to do what Attorney Manuel has asked me to, and I'm going to sentence Mr. Rouser to 15 days in the county jail, and I will give you credit for the 15 days that you served. I am going to waive fines and costs, and that will close this file.
Thank you, Judge.
Thank you.
Good luck.
All right, do they need paperwork?
Yes.
All right, I think we got some paperwork for you, and then, thank you. Let's see. There you go.
We'll just track here.
Oh, I forgot that you can't get out of the door until someone lets you. All right, I'll call 22T02364FY, people of the state of Michigan versus Dolores Ann Fox, and attorneys, you can place your appearances on the record, please.
This is prosecuting attorney William Walter, on behalf of people, Your Honor.
Ashley Patricius on behalf of Dolores Fox, who is also present standing to my left.
All right, thank you. All right, today is the day and time set for a preliminary examination. I know there has been a couple of different plans, I will say, in regards to this case, but I am holding plea paperwork in my hands again. Attorney Patricius, is your client planning on entering a plea today?
Yes, Your Honor.
Okay. Attorney Belser, if you can place the plea agreement on the record, please.
Thank you, Your Honor. This is, just for the record, this isn't normally the plea agreement sheet that we use. It's a form from the state that I got, so it's a little different, but the plea agreement is as follows. The defendant and the prosecuting attorney agree that the defendant will plead to one count of use of hydrocodone, will plead guilty. That's 333.740328B. The defendant also agrees to attend NA classes ordered by the court. Prosecutor and defendant agree to the defendant pleading under 771.1 with a recommended 6 months probation. The prosecutor agrees to dismiss the following charge, which is none. I've left spot 5 blank. The estimated sentencing guideline range is as follows. I've signed this agreement this morning.
All right, thank you. And Attorney Patricius, is that your understanding of the plea agreement?
Yes, Your Honor.
All right, and I see that you signed the plea agreement form as well?
Yes, Your Honor.
Okay. Ms. Fox, is that what you want to do today? You're going to plead to the charge of use of hydrocodone with the understanding that I will take that plea under the 771 statute, meaning I'm going to place you on a term of probation. So long as you comply with your probationary terms, you can come back in, withdraw your plea, and I will likely dismiss your case. Is that what you want to do? You understand, I see here that you're going to agree to attend NA classes as ordered by the court, and there's a recommendation of 6 months of probation. You understand that that's a recommendation by your attorney and the prosecutor. I'm going to send you for a substance abuse evaluation. So I may do 6 months. I might do longer. I might do shorter. I don't know. It's going to depend on the evaluation. You understand that? Yeah. Okay. All right. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth today? All right. I see that you signed your advice of rights, correct? You know, and you understand your rights. knowing and understanding all of your rights, knowing and understanding the charge and amended charge and the maximum possible penalty for the amended charge, how do you wish to plead to the charge of use of hydrocodone?
Guilty.
Need to make sure you're giving your guilty plea knowingly and voluntarily. So can you tell me, has anyone threatened you to get you to enter a plea?
No.
Has anyone promised you anything other than the plea agreement? I know you and Attorney Patricius have had numerous conversations at this point about this matter, but at this point, it's your choice to enter the plea.
Yeah.
Were you in Thetford Township in the county of Genesee in the state of Michigan on January 19th of 2021?
Yes.
And Attorney Patricius, I will let you take over from here.
Okay. Ms. Fox, on the day in question, at some point was your vehicle stopped?
Yes.
And during that traffic stop, was the vehicle eventually searched?
Yes.
Okay, and did the officers locate the substance of hydrocodone in the vehicle at that time?
Yes.
And where was hydrocodone, excuse me, where was the hydrocodone located?
I know it was in the back seat of the vehicle, exactly where I cannot be 100% certain, but I know it was in the back of the vehicle.
Okay, do you believe it was in your purse at the time?
I believe it absolutely could have been. Like I said, I was told it was found in my purse, but I'm not 100% certain where the officer found it.
Were you driving the vehicle?
Yes.
Okay, and was it your vehicle?
Yes.
Okay, and did you have a prescription for hydrocodone at the time?
No.
Your Honor, I believe that would be sufficient.
And the substance was tested and came back as positive as the substance of hydrocodone?
That's right.
That's
Yes.
stipulated too?
Yes, Your Honor.
Okay, all right, and with that stipulation, I will accept the plea as there is a sufficient factual basis to do so. And I do believe the plea was given knowingly and voluntarily today. As stated, this plea will be taken under the 771 statute. However, I do want a substance abuse evaluation, as I do with all use of substances cases. And so we will send Ms. Fox to our probation department for a substance abuse screening, and then we will set this matter for sentencing on August 29th, 2023 at 8:30 a.m. All right, anything else today, attorneys?
Nothing further, Your
No?
Honor.
All right, thank you, everybody.
Thank you, Ron.
Thank you. And then there were. Thanks.
Do you want me to do Mr. Brown's thing before?
No, let's do Mr. Brown first and then Mr. Gill.
Closing my laptop, I forgot. This one.
Two more. Technically six.
Mr. Brown.
So we will do the plea on Brown and then we will move to arguments and ruling on Gill.
Did the forensic on him, what, last Friday, was it?
Let's see.
Yeah.
Yes, 13th, June 13th. Wait, that may be wrong. 14th, sorry, July 14th. Good Lord, July 14th is when we did it. You need a nollie for count 2. You have it?
April, for some reason.
Okay.
So I changed your 4 to 7. It was on 4/18.
How's that work, Judge?
It was good.
Was
It was good.
Weather?
It rained a bit.
Did it? Yeah.
Yeah, but it wasn't,
Sunday was nice down here.
yeah, it wasn't as bad as what we thought it was gonna be, you know, we had plenty of sun. I got some sun. So,
Just like scattered kind of showers, nothing really.
yeah, at one point there was like a severe thunderstorm warning
Oh.
and it got pretty dark and it rained pretty hard, but you know, it lasted like an hour. No, and it didn't last all that long, so, yeah, it was good. We had a good time.
I woke up this morning and looked outside. There's an aquatic nuisance called milfoil. It's like a green, small little aquatic plant. The whole canal was green.
Where are you?
I'm on Lake Panema,
Oh,
Fountain.
yeah.
so yeah, right on North Road. It's a channel into the lake. So but woke up this morning, it was just all green.
Really?
Green soup. Disgusting.
Ugh. And so that's a no swimming, don't
Well,
go,
it's just a plant, so.
just, oh, so it's not gonna hurt you, it's just gross.
No, it's just gross, yeah.
So, no swimming, but only just like.
Yeah. Gross. They said, the swimmer's itch this year is really bad because the weather's been so warm and it's,
What causes that?
so swimmer's itch. The only reason I know what causes swimmer's itch is because my husband got it once
Oh.
and he was miserable for like a day. It goes away pretty quickly, but about a day. It's snails and goose poop. That is what it is. It's a combination of snails and goose poop and it creates they're little parasites.
Parasites.
Yeah, they're
Oh.
tiny little parasites
They bite?
and they bite your skin
Oh.
and it itches really bad for about a day or so and then it kind of goes away, but yeah, so I guess something about the warm water is making it,
Oh, okay. Yeah, no,
Increase.
we haven't had usually we have some geese coming down the canal, but I haven't really seen them this year. We had swans earlier in the year.
well, that's nice.
That's nice.
Okay.
Yeah.
All right, am I good? All right, this is case number 23T00274FY. People of the state of Michigan versus D'Angelo Dewan Brown. And attorneys, you can place your appearances on the record, please.
Prosecuting Attorney William Belser, Gate 411 on behalf of the other.
Sean McDermott on behalf of Mr. Brown, who is seated to my left in the box.
All right, thank you. Today is the date and time set for, I don't know if we had this set for a preliminary examination or a plea, but either way, I do have plea paperwork here in my hands. And so Attorney McDermott, your client is entering a plea.
That's my understanding, Judge, based on our last conversation. I didn't know if you wanted this to be, to try to do the no contest as well, or as we did before, or based on his statement at the end, whether you wanted a actual, factual basis provided by him.
I don't have a problem with no contest plea as long as the attorneys, if that's what you want, that's fine with me. People tend to change their minds and recollection of events as cases go on, so that doesn't really concern me too much. So I guess Attorney McDermott, it would be up to you. Which would you like your client to go forward with?
No contest.
No contest, okay. All right. Having said that, Attorney Belser, if you'd like to place a plea agreement on the record, please.
Your Honor, if I could actually read from your copy, I
You
don't have.
can.
Thank you.
You can just stand here.
Thank you. So the defendant having been charged as follows, count one is assault, resist, obstruct 750.81D1. That's a 2-year felony and or $2,000 fine. Count two is assault, resist, obstruct 750.81D1, 2-year felony and or $2,000 fine. The people will amend count one to include both officers named and an attempt, which is a 1-year misdemeanor and or a $1,000 fine. The people will dismiss count two. The defendant will plead no contest to count one as amended. No sentence. There's no sentencing enhancement, consecutive sentencing, Heider 7411 do not apply. And I signed that on April 18th.
Thank you, sir. All right, and Attorney McDermott, that is your understanding of the plea agreement?
I'm just gonna show Mr. Brown this agreement that we signed back on April 28th. with what was just read. Right now, you were charged with 2 felonies. They're dismissing 1 felony, reducing the other felony down to an attempt, which is a 1-year misdemeanor. Okay? You plead no contest to that, so the judge asks how you plead, you say no contest.
All right, and Attorney McDermott, you signed the plea agreement, correct?
I did, Judge.
Okay. So, Mr. Brown, is that what you want to do today? You want to plead to an amended charge of a misdemeanor count of attempted assaulting, resisting, or obstructing a police officer? Are you going to plead, you want to plead no contest to that today?
Yes, ma'am.
Okay, you sure?
Yes.
All right, raise your right hand. Best you can. There you go. Do you swear to tell the truth, the whole truth, and nothing but the truth today?
I do.
I see that you did sign the plea agreement form, correct?
Back on April 18th. Yes.
And this is the plea agreement form Attorney McDermott just went back over with you, correct?
Correct.
All right, and so this plea agreement form says that you're going to plead no contest to the misdemeanor charge of attempted assaulting, resisting, or obstructing a police officer, naming 2 officers. Is that right? Okay. I also know that you signed your advice of rights. And so do you know and understand all of your rights? Do you need me to read any of those to you again? No? All right. Knowing and understanding all of your rights, knowing and understanding this amended charge and the maximum possible penalty for the amended charge, how do you wish to plead to the charge of attempted assaulting, resisting, or obstructing a police officer?
No contest.
And Attorney McDermott, the reason for the no contest plea?
Lack of memory, Judge. Just if you recall, this case was sent to the forensic center based on some concerns that the family and myself raised after conversations with Mr. Brown.
Okay. And lack of recall of the event is certainly a reason for a no contest plea, and so I will accept that. I'm looking at a statement in support of probable cause that was submitted with the warrant and complaint. Attorneys, may I use that for the factual basis?
Yes, sir. Yes, Judge.
Okay. Statement in support of probable cause, as I stated, submitted with the complaint and warrant. Submitted by Detective Monroe, states that on Wednesday, January 25th, 2023 at 9:59 p.m., officer of the Grand Blanc Township Police Department was on patrol near Hill Road and Saginaw Street in Grand Blanc Township, Genesee County, Michigan, when he observed a vehicle with defective equipment. The officer attempted to stop the vehicle. The driver refused to stop as it drove through Heritage Park Plaza. After approximately 1.5 minutes, the vehicle stopped and the driver was ordered out of the vehicle. The driver was later identified as D'Angelo Dewan Brown, who sits here today as the defendant. Brown continuously disobeyed officers' verbal commands by walking away and refusing to take his hands out of his pockets. Brown was eventually handcuffed and walked to the police cruiser. And I believe that is a sufficient factual basis for, hold on, this named 2 officers, doesn't it? Brown, this additional statement on the statement of support of probable cause. Brown was uncooperative, refused to get into the police car. He was repeatedly ordered to get into the vehicle, stiffened his body, and was holding onto the door frame. One officer got into the cruiser to pull Brown in as the other officer assisted in pushing him into the door. All right, with that, I believe that is sufficient factual basis. Attorneys, do you agree?
Yes, sir. Yes, Judge.
Okay. I will accept that plea, as I do believe there's sufficient factual basis held within the statement in support of probable cause, which will become part of this file. And I do believe the plea was given knowingly and voluntarily today. We can move on to sentencing. And let's see, Attorney McDermott, what would you like to say on behalf of your client?
Judge, Mr. Brown, up until a year ago was completely healthy, functioning adult, very well accomplished basketball player. At that time, he became aware that he was suffering from numerous conditions, visual or audio vocalizations, I guess, as how he phrased it. He can correct me if I'm using the wrong terminology, and possibly schizophrenia. like I said, completely unknown to him. He was off his medicine at the time of the stop. And certainly out of character for him. He's as I like to call him, a gentle giant. He's a rather imposing figure, but if you get to know him and talk to him, he's quite a respectable young man. So I believe that was the cause of what happened with the officers was he was just off his medicine, and the situation escalated where it should have been just a simple traffic stop, and it turned into a lot much more. So I believe he's learned his lesson. I hope he seeks the mental health treatment that is available to him. And for the sake of his family, and I understand he has a young, is it a daughter? Young daughter now as well. That's gonna be, looking after him as well. So I just ask him that you credit to the time served. You know how many days you've been in?
About 66, 67 days.
Yeah, sounds about right.
I actually have a note from Gail that says 73 days.
Okay. So that's what we would ask from the clerk.
All right, thank you. All right, and Mr. Brown, I know that because you entered a no contest plea, your attorney doesn't want you to say anything about the date of the event. But is there anything you'd like to say in regards to sentencing today? My plan is to give you credit for time served, but if there's anything you'd like to say, you can.
I just want to apologize and say I appreciate you guys for everything. I appreciate you as well.
All right. Well, I hope, Mr. Brown, that when you get out of jail, that you are able to go and get the mental health care that you need. Make sure you stay on your medication so that this type of thing doesn't happen again. I tend to agree with everything your attorney stated. I don't think that you're a danger to society or anything like that, but you do need to take your medication, right? Right? Okay. All right. I'm going to sentence Mr. Brown to 73 days in the county jail. I'm going to give him credit for the 73 days that he has served. I'm going to waive fines and costs in this matter, and that will close this file. Okay. Anything else, attorneys?
Nothing from the people around.
Good luck, Mr. Brown.
Right. Yes.
I just found out that I can still go play professional basketball. So,
Oh, really?
Argentina.
Nice. That'll be exciting. Yeah.
Better start learning some Spanish, or Portuguese, or whatever.
It's either Argentina or Chile.
Oh, okay.
Neat. That's cool. Yeah, that's a good opportunity, and I hear you get paid pretty well to do that, and you get stay down there for a lot, but you get time to come home and whatnot too, right? Yeah. Thank you. All right, good luck, Ms. Brown.
Thanks. Have a good one.
You too. Okay.
Yeah, Mr. Gill on Zoom. We do.
All right. Let's see, Mr. Gill, can you hear me?
Yes, ma'am. I heard you, Judge.
Okay. Good. All right. I have case numbers 22T02859FY, 22T03286FY, 22T03397FY, 22T03398FY, and 22T03475FY. The people of the state of Michigan versus Robert Earl Gill. Attorneys, you can place your appearances on the record, please.
The prosecuting attorney, William Welser, PA 4181 on behalf of the people.
Sean, here on behalf of Mr. Gill, who is appearing via Zoom without objection. It's my understanding that a hospital letter was faxed to my office this morning. I've been in numerous courts this morning, so I was not able to receive that fax to bring to court, but if one is at my office, I will certainly forward that to court on receipt.
All right, and I do appreciate that. Although I do suspect that the district courts, well, Actually, that's probably not accurate. I'm gonna not say what I was about to say. We are here today. We took testimony in all 5 of these cases over a period of a couple of days. We ended that testimony. Both parties rested and requested an adjournment because there was quite a bit of testimony taken and there are quite a few charges here. So an adjournment was requested for everyone to organize themselves. And quite frankly, I needed that opportunity as well. So the matter was adjourned to today's date. So we are at the point first, before I allow the attorneys to make their arguments in regards to bind over. Attorney Belser, you had mentioned that there might be a chance that you may be altering some of the charges. Is that the case? And if so, what would you like me to know?
Yes, Your Honor, that is the case in one of the cases. It's I left one file back at the office. It is case number 22T022859 with the 2 witnesses, Carlton Troutman and Paula Dellinger. The original charge was, as all the others are, it's a false pretense of $1,000 or more, but less than $20,000. There were additional witnesses that never appeared on this matter, and as a result, between the 2 witnesses that testified, there was an amount of $500. So this has been amended from 1 felony count to 2 misdemeanor counts of false pretenses, $200 to $1,000. I didn't prepare the complaint. I believe that the court, since we're going to be binding over it, it's not necessary, but if it is, then I can have it prepared this before like
Well,
the end of the day.
because this is its own case,
Okay,
and they
separated.
both are being dropped to misdemeanors, I believe this case will actually stay with me and
Right.
not bind over with the other files.
Okay.
So with that, I would like you to do an amended, it wouldn't be necessarily an information because they're not felony charges, but I would like to do an amended charging document just so Attorney McDermott and his client can have that specifically.
It is actually prepared. I just would have to print it.
Good, okay, so let me make sure I understand correctly though. So this is going to be amended to 2 misdemeanor counts of false pretenses.
$200 to $1,000.
Okay. 200 to 1,000, and that is the 1-year misdemeanor, correct?
That's correct.
All right, so that's punishable by up to 1 year and or, is it 1,000 or 2,000? I think it's 1 year. I have the statute right here. I printed it out since I figured this might be 1 year and or $2,000. Okay. Yeah, and I assume, Attorney McDermott, that you don't have any objection to that.
No objection to that. I would just ask that you delay sentencing on that. I'm gonna try to obviously work on these as a package.
Right. Well, and what I'll probably do for this one is set it for an additional pretrial since Mr. Gill hasn't pled or anything of that nature. So I'll set it for additional pretrial and then I'll definitely give you some leeway when working on that. You know what? Why don't we go ahead and do that now so that I can set this file aside and. Let's do mid-August. That's about 30 days.
August 15 is our regular misdemeanor pre-trial day at 1 o'clock.
Okay. Attorney McDermott, we are looking at August 15th? August 15th, 2023 at 1 o'clock PM, but we could do 8:30 if that was better.
You know, I can be here, but I'll have a couple of Zooms on it to take care of. So if you don't mind me being like 15 minutes later, so after handling those Zoom calls.
That's fine. At 1 or 8:30, did you want?
1.
1? Okay, good. That's fine. That's fine. That's our normal pre-trial day, so Attorney Belser will have his hands full anyway. All right, so pre-trial. Okay, the prosecutor will get us a new charging doc on that one. Okay, now, in relation to the 1, 2, 3, 4 cases that are left, Attorney Belser, are you altering any of the charges on, or requesting to alter any of the charges on those cases?
No, you're not.
Okay. All right, then. I think I would like to take these case by case. I think that will be easiest. Attorneys, are you both okay with that?
Yes, Judge.
All right, let's go then to the case ending in 3286. And attorneys may make their arguments in regards to bind over. Attorney Belser, go ahead.
Your Honor. And just also really quick, I don't think this is going to be an issue at all, especially since we've had the one case separated, but I was just going to read it for the record that in the statute, if there is any point that there are certain amounts that they themselves don't reach $1,000, the statute itself provides that the value of land, money specifically, the value of money in separate incidents pursuant to a scheme or course of conduct within any 12-month period may be aggregated to determine the total value involved in the violation of this section. That's 750.218 subsection 8. I don't think that, as I said, I don't think that actually will be an issue here, but if for some reason there were amounts that didn't total 1,000, that separate courses of action related to the same scheme can be aggregated to reach the $1,000 threshold. But in the case for ending in 3286, I would ask that the court bind this over to the circuit court after, based on the testimony that we had received from both Daryl Evans and Pastor Llewellyn Jones. Daryl Evans, a resident of the city of Flint, 43 years, had an interaction at St. Peter's CME, a church on Pearson Road in Flint, Michigan, in September of 2021, with the defendant whom she was able to identify. Well, she did not make an identification, but she testified to the opportunity where she had met Robert Gill in person in September 2021, the last week of September 2021, in regards to repairing steps at a church at a value of $1,800, where he had provided a written estimate for the repairs requiring half down in relation to those steps. At that time, she had testified that there was a $900 check that was proffered from the church, from the church's checking account to the defendant, Robert Gill. Later, I believe it was the next day, she testified that she entered into a contract with Robert Gill for $1,800, which he provided a written estimate for repairs to the driveway of the church, which she paid $765 towards the payment. She testified also that there was a cashier's check provided by Pastor Jones, of $530 towards that as well, $375. I'm sorry, the $765 that she had provided for the driveway, and the remaining amount was provided by her husband. She testified to also providing $375 to keep Robert Gill's grandson out of jail. The total amount that I recorded from her testimony was $1,140 that she testified to having knowledge of being provided to Robert Gill by herself and her husband. Then Llewellyn Jones testified as an agent of the 501c3 nonprofit, St. Peter's CME in Flint, Michigan. That he's a resident, that he's the pastor and resident agent to that church. He also entered into a contract that he testified he believed in the year of 2021 with Robert Gill to repair the steps, which the $900 came from the church fund, the church that he represents, and then the $530 that personally came out of his own funds from the repair of the driveway. That would be a total of $1,430. The two total amounts then would be $2,570. Based on that alone and the testimony that while there was some partial work that was provided on the steps and on the driveway by individuals related or connected to Robert Gill, Mr. Gill never completed these contracted tasks. As a result, I would ask that this be bound over to the circuit court.
All right, thank you. And Attorney McDermott?
Judge, as to the $375 paid by Miss Evans' husband, we did not receive any direct testimony from Mr. Evans. He was here, being ready, willing, and presumably able, but for whatever reason, he chose not to testify. So we would ask that any demands to him individually be stricken and not included in the bind over, which would then probably, well, you're still, it won't change the charge because there's only one count, so it would just be the amount of $375. We would ask that amount not be included in the total. And I don't have I'm looking for a name of her husband. I just have Mr. Evans. I don't have a actual name.
Okay, well, let me just first say, I, in relation to this case, the other cases, and the previous case, I do appreciate the prosecutor changing some of the charges, because I did have a little bit of a problem of taking separate incidences at separate homes and separate people and aggregating those. I didn't feel that that was an appropriate thing to do. However, I do agree with the prosecutor in this situation, this type of situation, where it was one incident, one group of people in regards to one piece of property, and the money came from a couple of different areas, that can be aggregated together because of the nature of how things unfolded. So at this point, it is the burden of the prosecutor to show by probable cause basis that there is that this defendant committed this crime in this venue, and I do find there is probable cause to believe that Robert Earl Gill did with the intent to defraud, cheat, or make use of false pretenses to obtain from a person money, personal property, or the use of an instrument, facility, article, or other valuable thing or service having a value of $1,000 or more, but less than $20,000, contrary to MCL 750.2184A. That is false pretenses, $1,000 or more, but less than $20,000, and is a felony punishable by up to 5 years and or $10,000 or 3 times the value of the money or property involved, whichever is greater. The testimony that we heard was from Ms. Daryl Evans, and then as well as Pastor Llewellyn Jones, who stated that Mr. Gill met them to give them an estimate at their church, St. Peter's CME Church. That's at 771 East Pearson Road in Flint in the county of Genesee in the state of Michigan. And that there was monies paid to him to fix some steps, as well as to repair what was called a driveway and a parking lot. I got the same thing, but referred to as driveway and or a parking lot. And those things never occurred. A couple of things may have been started, but the work certainly was never finished. The church itself, St. Peter's, provided to Mr. Gill $900. Testimony was that Miss Daryl Evans provided Mr. Gill with $765. She also testified that her husband provided Mr. Gill with $375, and I believe that may have been part of Mr. Jones' testimony as well. I am going to not strike that. There was testimony as to that amount of money, whether or not, that holds up with the jury or not, but as probable cause basis, I do believe that is enough to include that $375 in this charge. And then there was an additional $530 that was provided Mr. Gill from the pastor Llewellyn Jones. That, by my count, totals to a value of $2,570. As I stated, that money was paid to repair and replace stairs, and repair a driveway / parking lot. Those things were somewhat started but never completed. And Mr. Gill never returned any of those funds and never completed the work. And so, as I stated, I do find there's probable cause to believe that crime was committed by Mr. Gill in this venue. And so this file will be bound over to circuit court. Okay.
Judge, just so I'm clear.
Yes.
We're doing one count.
One count. Yes, there's one count. There is one count, and there is the habitual offender fourth offense notice as well on the complaint. Okay. I did not. This is going, well,
They will
They all-
consolidate
yeah.
however they see fit once they're there. If more than one is.
this is the lowest case number, so
It doesn't mean-
I'm going to guess that they're all going to be consolidated to this judge, but this case is assigned to Judge Kelly. So Judge Kelly will set the new court dates, but the cases will be consolidated, I'm sure. I'm not 100% sure as to which judge, but. All right, so. T033397 is the next case we will move on to. And so, attorneys, when you are ready, Attorney Belser, you can make your argument in regards to bind over as to this case.
I'm sorry, Your Honor, I missed the last 4 digits.
3397.
Thank you, Your Honor. So in regards to case 3397, we heard testimony from Carolyn Mayo. Carolyn Mayo, who lives at 1309 Hibiscus Street, Mount Morris, Michigan, 45458. She is a Genesee County resident. 5 years. She had an interaction with Robert Gill that she testified to in August of 2022. At that time, Mr. Gill, she testified, had went to a friend of hers door to see if she needed a roof repair. He quoted to her $300, which the individual said no. She testified that he gave her an estimate for her own roof of $2,800. Initially saying half down, but then accepting $1,200 down and an $800 check, which she knows to be cash because it's her account. She had the funds withdrawn. She personally gave the check to Robert Gill. And then the next day, she provided him a $400 check, which in the same right, he had also cashed that same check. Robert Gill wrote out an agreement for $2,800 with $2,000 to be paid upon completion when she first provided the $800 check on the first day that she interacted with him in August of 2022. At that time, Robert Gill, with 8 of his associates, took off all of the shingles off of her house, but then never came back to put the shingles back on the house. She was provided after this after her testimony was aired on ABC 12. There was an effort made by the defendant to provide 2 money orders, which were both $600, they actually paid in full what had been taken, but as the statute, or as the statutory language reads for false pretenses is that the individual does with the intent to defraud or cheat, make or use make false pretense to obtain from a person money having a value of $1,000 or more. Based on the testimony that was provided by Carolyn Mayo, he had received $1,200 from her for work that he had no intention of doing. He provided a written agreement for $2,800, $2,000 down, total $1,200, and at that period of time had kept that money with the intent of not returning it to her. Based on that testimony, the standard of probable cause, I believe that the people have met that standard and would ask that it to be bound over to the circuit court.
All right, thank you. And Attorney McDermott?
Is that the only case on this one?
That's the only individual that testified to that one, yeah.
Your Honor, we would object. The money was given to Mr. Gill and it was promptly returned. Miss Mayo even, on questioning by myself, asked if she was out any money for the roof or anything else or due any money. She said she was completely made whole. So we object for the record to the bind over based on those assertions by her that nothing was due her.
All right, thank you. Boy, well, in relation to this case, I did do some research myself because I did have a question on whether or not what Attorney McDermott has just stated, that, you know, because Miss Mayo did get her $1,200 back, whether or not that negated the charging of this charge, and it does not, from what I have found. The question is not whether or not the money or thing obtained, you know, whatever it might be in whatever specific case, is returned. The question and the crime occurs with whether or not there was an intent to defraud or cheat when that money was obtained, and that certainly has been shown by a probable cause basis here. Miss Mayo did testify that she lives at 1309 Hibiscus Street in Mount Morris, County of Genesee, State of Michigan, and that she met Robert Gill in August of 2022, and that she contracted with him to fix her roof. Contract was for eventually, after some discussion, was for $2,800. She gave him first an $800 check and then wrote him another check for $400, and she actually stated he wanted more still, but she told him no. At that point, she had some suspicions about what was happening. So the total amount of money that Miss Mayo gave to Mr. Gill was $1,200. And the only reason from the testimony that I could discern that money was given back was because Miss Mayo was on the news, and that prompted Mr. Gill to return her money. She is the only person in the series of these cases that did get her money back. So I suppose that is a good thing. However, Mr. Gill did have individuals come over and take the roof off of her home, left it in that way through the shingles in the yard, left the home without a roof, and never came back to fix that. Luckily, she was able to get a company to come in and fix that roof for her. But the simple fact is that Robert Earl Gill did, with the intent to defraud or cheat, make or use a false pretense to obtain from a person money, personal property, or the use of an instrument, facility, article, or other valuable thing or service having a value of $1,000 or more, but less than $20,000, contrary to MCL 750.21848. And that is the felony, punishable by up to 5 years and or $10,000 fine, or 3 times the value of the money or property involved, whichever is greater. This felony complaint does have a habitual offender fourth offense notice attached to it as well. Because probable cause has been shown, the matter will be bound over to circuit court. This case is with Judge Newblatt, but as stated previously, I'm sure these cases will be consolidated. All right. Anything else on this matter?
Nothing from people.
No, pretty much.
No, okay. Okay. Next one is 3398, 22T03398FY. All right, Attorney Belser, when you're ready.
Your Honor, actually, if the court would allow just a brief recess, I'm realizing now that I don't have the testimony from Mr. Ridley in my file for this, this one case, if,
Okay. Why don't we do,
Petrowski, 3475?
yes.
Okay.
Why don't we do the other one and then we'll come back to that file and give you a moment to get your notes. Okay, so we're actually going to handle 22T03475FY 3475. We're gonna do that one right now. Okay, attorneys, arguments.
Thank you, Your Honor. Same as the past couple files, the people would ask that this be bound over the circuit court based on the testimony that was provided by Ronald Petrowski, an 80-year-old citizen of Mount Morris, Michigan, at 3242 West Goldwater. As a resident there 30 years, he testified that he had an interaction in either August or September of 2021 with Robert Gill, where Mr. Gill had offered to provide a new layer of blacktop on Ronald Petrowski's driveway for an estimated amount of $2,400. At the time that Mr. Petrowski met Robert Gill, Robert Gill had provided to Ronald Petrowski a written estimate for $2,400. He testified that he additionally paid multiple sums for several issues regarding broken down tools and necessary repairs. In total, Ronald Petrowski testified that he had provided to Robert Gill $2,680. Based on the testimony that Mr. Petrowski provided, I believe that the people have met the probable cause standard to have this bound over due to the work that was never provided to Mr. Petrowski for the driveway and the sidewalk as well. We'd ask that this be bound over to the circuit court.
Okay, thank you. Attorney McDermott.
Object for the record.
All right, thank you. All right. Once again, prosecutor has burden to show by a probable cause basis that a crime was committed. This person, the defendant here, committed this crime in this venue being Genesee County. And I do find there is probable cause shown here that Robert Earl Gill did with the intent to defraud or cheat, make or use a false pretense to obtain from a person money, personal property, or the use of an instrument, facility, article, or other valuable thing or service having a value of $1,000 or more, but less than $20,000, contrary to MCL 750.2184A, which is a felony, punishable by up to 5 years and or $10,000 or 3 times the value of the money or property involved, whichever is greater, and there is habitual offender fourth offense notice. Yes, we did hear from Mr. Petrowski, who testified that he lives at 3247 West Coldwater Road in Mount Morris, which is in Genesee County, Michigan, and that he hired Mr. Gill in 2000, stated he believes it was September 27th, 2021. And Mr. Gill came to him, introduced himself, and offered to take out asphalt and 2 sidewalks, and estimate was for $2,400. Asked for half down, and as Mr. Petrowski stated, he, quote, kept coming back for more. Mr. Petrowski testified that he ended up giving Mr. Gill a total of, the figure I actually have is almost $2,600. He said it was $2,580 was the total that he gave to Mr. Gill. Mr. Gill did have the things removed, and then, similar to the other cases, never finished the work. Mr. Petrowski did state that he brought some crushed asphalt and actually brought that asphalt in with him. and referred to it as a couple of different terms, but we'll use the one term of garbage. In that it wasn't what was contracted for. Of course, the work never was completed. And Mr. Petrowski did state that he had to pay another company to come in and fix it. And it was over $5,000 to do that. And that company had to replace everything that Mr. Gill was contracted to do. So as stated, there is probable cause to show that the crime of false pretenses, felony crime of false pretenses, 1,000 or more, but less than 20,000 was committed in this matter. And the matter will be bound over to circuit court. Looks like this case is assigned to Judge Piquel, but as stated, they will likely be combined. I will make a note as well that Ryan Sims did testify in this matter, that he performed some of the services at this West Coldwater Road, and Mr. Gill contracted with him to do this, as well as he said some other jobs as well, and that he performed the services and Mr. Gill never paid him, and that Mr. Gill owed him $400. That's, I don't think is being included in this case. However, sounds to me like there might be another case for Mr. Swims, but I'll leave that to the prosecutor's office. All right, anything else, attorneys, on this matter?
Nothing from the people.
So the count 2 and 3 are being discussed then?
I'm sorry.
This count 1? This one is 3 counts.
Oh, I don't see.
No, this is.
I only have one.
3475, and that's just the one.
Oh, this is 3, 4,
The one
7,
with
5?
3 counts. I need to run and grab my notes really quick.
Oh, okay.
Right. Okay. Ooh, okay. All right, anything else then?
Nothing from.
Nothing.
So we're not including Mr. Sims on this file?
No.
Nothing further.
Okay, thank you. Okay, the prosecutor has requested a short recess so that he can get his notes on the very last file. We'll allow you to do that, Attorney Belser, and we will patiently wait.
Thank you.
Are there no contact with every one of these parties?
No contact order? You know what? I don't know. There's no contact order in the last one, 3398. That's the only one I have up here left. We can look.
There is on everything.
I would assume, but let's check just to make sure. So when I assume things usually ends up being. No contact. That one. Contact. That one. Yes, no contact on all.
Okay. This last one is just the charter, that's what he's looking for?
I think he said he's looking for Todd Ridley's,
Oh, Ridley, yeah,
Ridley's
that's the only one he's got left.
testimony.
Uh,
Yeah, well, this is the one where there's 3 counts, I believe, because there's 3 alleged victims, each over $1,000.
I haven't seen any testimony on any of the other ones.
Oh.
So I'm missing something.
I have pretty good notes.
Do you have any other testimony on?
We had testimony from Tom Ridley and from Sean Malone.
Oh, okay, yeah, there we go.
Yeah.
Ridley and Malone.
So we'll discuss this. That goes back.
Yeah, I just want to make sure. So if you can shred that. I don't have a staple color.
You want to stick it out in the thing?
No, I think that's it. Ready? Okay, we are still on the record in the Gill matters. We are on the last file of the 5 we had today. This is the file ending in 3398. And so, Attorney Belster, if you'd like to make your argument in regards to bind over, please go ahead.
Yes, thank you, Your Honor. So, as the court remembers, the very first witness that we received testimony from was Todd Ridley. During that testimony, he stated that he had provided to Robert Gill $400, and he was also promised $1,500 himself from Robert Gill to do some labor on a project at 3301 Gamble Lane, which is in Flint Township in Genesee County. As the statute states, while all of these other cases have been strictly with monetary value, just currency exchange, that the false pretenses, the individual can intend to defraud or cheat for money, personal property, but etc., as well as services. The $1,500 that Todd Ridley testified to, he said that in his experience working construction, that he was familiar with that type of work, and that the $1,500 is an estimate that he would have provided for the labor that he did provide. He never received payment for the labor that he provided to in the benefit of Robert Gill. And at that time, he was able to personally identify Robert Gill. He also provided, as I had stated, that he had given $400 to Robert Gill that he was never paid back, as well as that the testimony from Sean Malone. Sean Malone stated that he is a resident at 6422 Garden Drive in Mount Morris, 48458, and that he was helping his friend Monica Pearson, who needed repair of her driveway at 1252 Klein Street in Mount Morris. It was in 2022, in the summer of 2022, that he interacted with Robert Gill, where he had contracted with Robert Gill. Robert Gill was the individual who provided the estimate for the driveway that was going to be repaired. It was $6,000, and as part of his estimate, he required half down payment. Sean Malone testified that he himself paid a cashier's check of $1,000. He testified that he had personal knowledge that Monica Pearson provided a $2,000 check to Robert Gill in relation to the work that needed to be done on the driveway. Robert Gill did come back later that week to start work on the driveway. He never completed the work. There was a $1,000 check that was provided by Sean Malone after the original $1,000 check. It was as a result of what Robert Gill had stated, that his granddaughter had been killed in an accident. The cashier's check was meant to help with retrieving the granddaughter's body, then $1,000 for more material. Sean Malone testified that he estimated that there was a yard of sand that was dumped in the driveway of 1252 Klein Street for the what was it seemed the attempt to repair the driveway. Based on the testimony from Sean Malone, he himself provided $3,000 to Robert Gill. There was the $2,000 that he testified he had personal knowledge from Monica Pearson. And then the $1,500 in labor and $400 of the check that was given to Robert Gill from Tom Ridley. Based on all of that testimony, I believe that the people have met the probable cause standard and would ask for this to be bound over to the circuit court.
All right, thank you. And Attorney McDermott.
Judge, I believe as to Mr. Ridley, there was no written agreement as to the machine work. I know he claimed a value of 1,500. My client said that the agreement was 800. As to Mr. Malone, my notes seem to indicate that he gave to Mr. Gill $2,000, and then he alleges that Monica Pearson, who did not testify, I believe, also gave Mr. Gill $2,000. So we'd ask that any amounts stated by Mr. Malone on behalf of the other party that did not testify be stricken, and you only include the amount that Mr. Malone has direct loss as to Mr. Gill.
All right, thank you. All right, once again, prosecutor does have to show by a probable cause basis that certain crimes were committed, that these crimes were committed in this venue and committed by this defendant. And once again, the prosecution has reached their probable cause basis. There was testimony from 2 people in this matter. There are 3 counts of felony false pretenses here, and I do believe that all 3 of the false pretenses counts were shown by a probable cause basis through that testimony. Todd Ridley did testify that he's been a contractor for 35 years, and in August of 2022, he was working. Mr. Gill approached him, wanted to use some of his machinery. They ended up making a verbal agreement that Mr. Ridley was going to use his tools and machines and whatnot to do some work for Mr. Gill, and that Mr. Gill was to pay him $1,500 for that work. And then he additionally, Mr. Ridley additionally gave to Mr. Gill a $400 check because Mr. Gill stated he needed it to finish another job, and Mr. Ridley was never paid back the $400 check and was never paid for the work that he did do and was supposed to be paid $1,500 for. And so the total amount owed to Mr. Ridley that Mr. Gill obtained through false pretenses is a value of $1,900 total. And that is for $1,500 for the services and $400 for the actual check that was given to him. That is one of these counts. We'll say count 1, false pretenses, $1,000 more, but less than $20,000 that Mr. Gill did with the intent to defraud, cheat, make, or use a false pretense to obtain from a person money, personal property, the use of an instrument, facility, article, or other valuable thing or service having a value of $1,000 or more, but less than $20,000, contrary to MCL 750.2184A, and that is felony punishable by up to 5 years and or a $10,000 fine or 3 times the value of the money or property involved, whichever is greater. Second person we heard from was Sean Malone, who stated that he lived at 6422 Garden Drive in Mount Morris on the County of Genesee, State of Michigan, and that his neighbor lives at 1252 Klein Street in Mount Morris, County of Genesee, State of Michigan. And that neighbor was a Miss Pearson, Monica Pearson, I believe was her name. And that Miss Pearson and Mr. Malone contracted with Mr. Robert Gill in the summer of 2022 to do the work on a driveway on Miss Pearson's property, the Klein Street property. And that is actually some of the work that Mr. Ridley was testifying to that he did, not all of the work, some of the work. Through the process of contracting with Mr. Gill to redo the driveway, Mr. Malone and Miss Pearson were quoted a total of $6,000, and Mr. Gill wanted half down, which was $3,000. And so Mr. Malone testified that he gave Mr. Gill $1,000 and that he knew, I agree with the prosecutor through personal knowledge that Miss Pearson gave Mr. Gill $2,000 check. Those were both given in cashier's checks and both cashed. Mr. Malone stated that there was someone, Mr. Ridley, who came out and did some work, but not much, dug out the driveway, and then that was all. The driveway was never completed. In addition to the $1,000 that Mr. Malone initially gave Mr. Gill, Mr. Malone did testify that Mr. Gill came back and stated that his granddaughter had died and he needed money to go to that funeral. And so Mr. Malone, in his kindness, similar to the kindness of the other people involved in these situations, did give Mr. Gill another $1,000. And then after that, Mr. Gill came back and asked for yet another $1,000. So total amount that Mr. Malone gave to Mr. Gill was $3,000. Total amount Miss Pearson gave to Mr. Gill was $2,000. And once again, the work contracted for was never completed, and these individuals never were returned their money. So count 2 and count 3, false pretenses, they're both the same. False pretenses, $1,000 or more, but less than $20,000. That on these 2 counts that Robert Earl Gill did with the intent to defraud or cheat, make or use of false pretense to obtain from a person money, personal property, or the use of an instrument, facility, or article, or the valuable thing or service having a value of $1,000 or more, but less than $20,000, contrary to MCL 750.2184A. That's a felony punishable by up to 5 years and or $10,000 or 3 times the value of the money or property involved, whichever is greater. Again, that is count 2 and count 3. There's a total of 3 counts, as well as the habitual offender 4th offense notice on this felony complaint. The matter will be bound over to circuit court on all 3 counts. And this file is assigned to Judge Piquel, although as stated previously, I'm sure they will be combined, but I don't know which judge they will be combined to. So
Was there a new information? Because my notes indicate that the third count was a 200,999. Okay. Third count I'm showing was a 200,999.
oh, look at that. Well, wait, hold on. That's not, I do see that. Was there a new? That's not what I was.
To amend that complaint, Your Honor.
Yes, I thank you for pointing that out, Attorney McDermott. That is, count 3 is 200 or more, but less than $1,000, which is a misdemeanor. And Attorney Belser, you just stated you would like to amend that to the higher charge of the felony count?
Yes, Your Honor, and I'm doing a handwritten amendment.
Okay, that does need to be done. Once again, thank you, Attorney McDermott, for pointing that out. But I am going to permit the prosecutor's office to amend that 3rd count to the felony charge of false pretenses, $1,000 or more, but less than $20,000. it's pretty clear that each of these three victims in this case provided to Mr. Gill an amount between $1,000 and but also less than $20,000. So that would qualify as the felony charge. Okay, and with that, anything else?
No, Judge.
All right, thank you, everybody. Okay, Mr. Gill, we are all done. You can go for now. Make sure to keep in contact with your attorney about your next court dates.
That's